Thanks for joining us today for the next in the series of the CyberSideChats. This one on a brand new California law that was frankly enacted on a rather short notice that fundamentally changes in some ways the landscape for privacy for companies dealing with California consumers. The California Consumer Privacy Act of 2018 really represents a compromise between industry and consumer advocates that was an option rather than a ballot initiative that frankly could have gone further down the road for privacy protections in California. One of the first key things to understand is the definition of what personal information is under this law. As you can see from the slide, it is a broad definition that includes a number of different identifiers, including IP address, email, address, account name, SSN, driver's license number. It also references other categories that are included in other California laws, as well as certain protected classifications under California or federal law. Biometric geolocation data, as well as a number of other categories, are included, and this is important to understand when you're looking at the law. Although, as we'll see later in the slides, there is another definition that already exists in California law that is referenced, that is narrower, that frankly is relevant, particularly regarding the remedies. Consistent with most other laws that define personal information in the United States, there are certain exceptions to the definition, including information that's publicly available or available in certain other ways, as you can see from this slide. In connection with certain remedies, as I noted before, there is a narrower definition of personal information that is picked up from California Civil Code 1798.81.5, which is California's data security law that has been on the books for a significant period of time. This definition, as you can see, is a much narrower definition of personal information and much more consistent with the security breach laws you see in the United States, generally speaking. Turning to the substance of the law itself creates a number of different requirements that businesses must meet. It also extends, in essence, the right of privacy that exists in the California Constitution and extends certain new rights to consumers in California that they previously did not have. One thing to note regarding the obligations on business, there are distinctions drawn between the obligations that are placed on a business that merely collects information versus a business that collects and then also sells that information. Focusing first on the rights that were created for the consumers, there are two main broad issues that businesses have to think about. One is disclosures of categories, and then there's also a right for a consumer to have disclosure of specific pieces of personal information that has been collected about the consumer. In this case, the law creates a right for the consumer to ask a business not more than twice during a 12-month period to disclose the things that are on this slide. Obviously, some are categories, and that's in some ways a little similar to California's existing Shine the Light law, although this applies in a different way. But then there's also a disclosure requirement for the PI, as you can see in the final bullet point. And this is similar to some global trends we're seeing. There are some portability requirements as well, and we see that in U.S. law at some level with HIPAA, but also, again, on a global basis. And so there's format requirements, there's the ability for a business to extend certain of these disclosures, as we'll see on future slides. But the key thing here is the consumer is limited to asking twice in a 12-month period. The consumer has to take an affirmative verifiable action to request it, and there's some details around that as well in the law. But again, businesses now have to disclose more information than they would have previously. Consumers were also given the right to request deletion of their data from businesses as well as certain of the business's service providers. And the law also requires the business to disclose this right to consumers. This, again, I think picks up a trend we're seeing on a global basis, including in Europe. And it's important to note that this is a step that has not previously really been taken in the United States, but we now see this coming online, if you will, in California. There are exceptions to the deletion right. And it isn't simple as saying all information may be deleted no matter what. There are abilities to keep the data for legal obligations, detecting security incidents, as well as other exceptions. Consumers were also given certain rights in relation to businesses that sell their information, and these typically fall into two categories. The consumer has the right to have certain information disclosed to him or her, and also the consumers now have an opt-out right for the sale of their information to third parties. This ties into California Shine the Light law in certain ways, because in the past, one of the ways to comply with Shine the Light was to grant the opt-out right for third parties. Now we're seeing, rather than it being one way to comply with a law, that California consumers have the affirmative right to request that a business opt them out of the sale of their information to third parties. Turning to the obligations that are imposed upon the business, you can see that there are certain requirements about how the business is set up to receive these kind of requests, and that includes, at minimum, a toll-free number and obviously a web address if a business has one. The definition of business in this law is important to note. It does not apply to every single business out there. There are certain definitional requirements you have to meet, but it will apply to a lot of businesses that interact with California consumers either way. And then you can see that if a business does receive a request, then the information that's requested must be disclosed free of charge and within 45 days of the consumer's request. An extension can be obtained. The business can simply say it needs more time and not provide all the information within the 45-day time period. There are some additional time periods related to these that can be obtained by a business, but those will be covered in future slide casts on this law. And you can see the disclosure of the categories mirrors, obviously, the rights that a consumer has that we talked about on the previous slide. And there are some, again, formatting requirements. And if information is delivered electronically, it must be portable. This law also mandates that certain disclosures be made to consumers at the point of collection of information or before the point of collection. And this generally relates to the categories of personal information to be collected, as well as the purposes that the information will be used for. We see this again in European laws and in other laws, and this is at some level a purpose limitation requirement that has been put into this law. And as you can see, if collection beyond the disclosed categories is to occur, then an additional notice must be provided. There's certain disclosures and certain forms that are listed here in the sub-bullet points, including the implementation, if you will, of the right that a consumer has to have their information not be sold to third parties. Businesses also have to make certain disclosures in their online privacy policy or in certain other formats if they don't have one, though the reality is most businesses do have some form of online privacy policy, and you can see there's much more detailed disclosures that will likely have to be made going forward in privacy policies, and these, according to the law, should be updated at least once every 12 months. The law also imposes some form of training obligations on certain key employees in businesses that are subject to the law. It also requires businesses to honor the opt-out right in something that is, I think, again, probably tracking laws on a global basis a bit. We're starting to see some additional restrictions on the sale of information regarding consumers who are under certain ages, and this law certainly does pick that up, particularly regarding children under 16. There's also an anti-discrimination clause in the law that does not permit businesses to discriminate in certain ways, at least for consumers exercising their rights, though businesses can offer financial incentives to provide information and for sale of information, and there is the ability to charge different prices for certain services. One other thing to note is the law does not impose an affirmative obligation to retain information for one-time transactions if the business isn't necessarily retaining that information already and it's not sold. The remedies provided by this law are a somewhat complicated picture. The main remedies that a consumer appears to have are tied to a narrower definition of PI, as noted above. It really tracks 1798.81.5. And there's additional remedies that appear to be there for the state attorney general. Given how quickly the law was amended and then passed, there's the potential that these remedies might have to be changed in the future. There are it appears, some questions or ambiguities around what exactly the remedies are and how they will play out for each different alleged violation. But there are additional remedies, including those around, in essence, breaches, and that definition again ties into the definition that we already have under California law for security breach and also for data security. It's not clear that those remedies will necessarily apply to every breach. It will remain to be seen how whether the law is amended or not before it goes into effect, and also how it will be interpreted. But the key takeaway is there are additional remedies that consumers may be able to avail themselves of under this law. So what are next steps to think about as we look at this law as it will be implemented in the future? Well, one of the key components will be understanding what information flows are at some level because of the disclosure requirements regarding categories of information. Implementing systems to support consumers exercising the rights that they now have, as well as letting the business meet the deadlines on disclosure to comply with those new rights is also critical. This is going to include likely amending online privacy policies, but also setting up systems so that consumers can opt out and those can be acted on within the timeframes required by law, as well as also dealing with the inevitable deletion requests and setting policies and procedures to determine when and how information should be deleted. Whether this law will be amended before it fully goes into effect to try to perhaps remove some of the ambiguities that are out there remains to be seen. But right now, it is the law in California, though not effective for a good bit of time. So businesses need to start thinking about what they're going to do and how they're going to implement this law when it finally becomes effective.